is that I have brought this upstairs. I don't know if you can see what I'm holding here. Hold on, I'll switch my background off. One moment, please. As my recognition of where I am with you all virtually.
Is that a Turkish coffee pot?
Most
Yes.
certainly is.
Oh.
And it's on the label. I won't tip it up because it's full of hot coffee, but it has Istanbul on the top here.
Oh.
And I'm very,
Jeffrey, you should come soon again.
I would very much like to. I'd love to. I miss it. I have to say, I miss all the travel, but one of my favorite places for many years, I've been about 6 or 7 times, is of course Istanbul.
So hopefully once all this over, we will have real meeting, live meeting in person in Istanbul then.
Absolutely, that will be really great. Now I will go back to my other background. Unless you all think it's better for me to be seen as I am in my room, it's up to you.
Hi, Jeffrey. Nice to meet you. This is Lorenzo.
Hello, Lorenzo.
Hi,
Lorenzo.
hi.
You're in Roma, are you?
Yeah, yes, I am. Yes, I
Another
am.
beautiful city. Lovely.
Exactly.
Lovely.
Exactly.
Excellent.
Thank you very much, Jeffrey. I very much appreciate your being here, and I'm honored to meet you. Actually, it's not the first time. You probably don't recall, but you lecture us in Southampton a few years ago. I think 2013 or
Yes.
2014.
You had my Road of Shipbrokers and History of the Baltic Exchange talk.
Yeah, right. Exactly.
With the wonderful, much missed Richard Shaw.
Exactly.
In those days, we had all the good and the great in Southampton. So you were doing your LLM there, I guess.
Yeah, correct.
So we had Yvonne and all the other greats. Yes, great.
Filippo Lorenzon.
Filippo, yeah, of course.
Andrea
He's now in
Lista.
Darien, I think. He's now in Darien.
Yes. Exactly, it's in Darien. Yeah.
And Yvonne Bartz has gone to Queen Mary's, I believe. And Charles de Batista is now a full-time barrister and arbitrator.
Not many of that time are in Southern at the moment. You know, I think Andrea Lista also left. I think he's in Exeter, if I'm not mistaken.
Yeah.
Ilma Larsson, Joanna Ilma Larsson, he left. Is still in Southampton.
That's right.
Paul Todd also. Paul Todd. I don't think he's in Southern anymore.
No, I think he's gone. I believe all but about 3 have left, which is a pity. There must have been some change at the top, and they all decided it wasn't for them.
I have great memory of the year in Southampton. It was amazing. It was amazing year. It was amazing people, amazing. I'm a little nostalgic of that time. You know, I remember Filippo Lorenzon used to tell me, well, don't miss anything, grasp everything of that year, because this is going to be the year you will remember for the rest of your life. And then after 10 years, almost, no, less. Anyway, I say he was true. It was true.
Indeed. I'm just pouring my coffee, excuse me.
So we are actually live on Facebook, and I think if we're all ready, because we have also speak attendees that are joining right with us, in 1 minute, I think we can start.
That's fine. Good. Sinan, will you be introducing each of us, or do we give a little bit of background of ourselves? Or
I will be introducing. In the meantime, we will also have in the screen your all full bios that you have sent to me. So once we start, our colleague who helped us in this, preparing the flyer and all the media process, he will be sharing in the screen your full bio.
Good.
Great. Now it's sharp 6 UTC. So I would like to say hello to everyone. Welcome wherever you are, whichever part of the world you are listening. So, well, as you know, today's topic is connected with the recent grounding of one of the world's largest vessels, weighing nearly 220,000 tons in the Suez Canal, the Ever Given. And that grounding raised a number of questions over the recoverability of losses sustained by vessel owners, charterers, cargo owners, and countless other entities extending well beyond the maritime sector. And today, in fact, we have 5 amazing speakers with us to discuss these issues raised with the Suez Canal blockage. So before starting immediately the discussions, I would like to briefly introduce them. So I would like to start with Lorenzo Macchi. Lorenzo is a founding partner at MEPLO, which has offices in Rome, in London, and in Izmir. He is the head of the shipping and international commercial law practice. He is very active in Turkey and in the Emirates, and he is also a member of the technical committee of the International Order of Chartered Accountants of the Emirates. Lorenzo, perhaps you would like to say a couple of words, so I will leave you the stage quickly.
Hello. Yes, just briefly, thank you very much, everyone, for being here. It's a real pleasure. I'm truly honored to have all of you in this webinar. Thank you a lot, Jeffrey. Thank you, Murat, Elif, Norman, and last but not least, of course, Sinem, our associate in the Izmir office. And thanks for moderating and truly committed to the shipping cause. We already have heard a lot and read a lot about this casualty, but I guess this is an occasion for investigating the topic a little bit more, to keep monitoring what are the commercial and the legal implications of this extraordinary event. And perhaps, thanks to your help, we can see things from different angles and the point of view. Thank you very much.
Thank you, Lorenzo. I totally agree. Jeffrey Blum. Jeffrey has been involved in shipping and trading since 1972. He's a generation of a shipping and logistic family, a member of Baltic Exchange since 1976. And he's also the chairman of Baltic Expert Witness Association. He founded Interlink International Trading UK Ltd in 1994. And in 2002, Jeffrey founded and is the principal lecturer with 30 guest lecturers of Maritime Education and Trading Ltd. He's a visiting professor at the World Maritime University in Malmo. And also, he is a visiting professor at the Shanghai Maritime University. So Jeffrey, warm welcome. It's an honor to have you with us today. Well, actually, I had the privilege to get to know Jeffrey last year in another webinar where Young Ship Turkey and ICS Turkey Development Branch had been organizing. And since then, it has been always a pleasure to work with him. Thank you, Jeffrey. Welcome. Hello? Oh, I think I lost the connection. Is that correct?
I hear you loud and clear.
Oh, okay, that's fine.
I went offline for a second, but you're back.
Okay, thank you. Thank you once again, Jeffrey. I would like to continue with Murat Sumer. Murat Sumer read law at the Ankara University and has been admitted to the bar as an advocate in Turkey. Mr. Sumer currently works as a lecturer in international maritime law since 2019 at IMAO International Maritime Law Institute based in Malta, and acts as an examiner for the Faculty of Laws, University of Malta, and a visiting lecturer at Ankara University Maritime Law Center. Very warm welcome, Mr. Sumer. It's our pleasure to have you with us.
Thank you, Sinem. Greetings and good day to all, whether it's morning, afternoon, or the evening, wherever you may be. It's an evening, actually, here in Malta. And thank you for the kind invitation. It's absolute pleasure to be here.
It's our pleasure. Thank you. Elif Torre. Ms. Torre had an MSc in finance at the Lancaster University in UK. Currently, she's doing a second postgraduate in international maritime law at World Maritime University. And before joining to Peel Ferrari, she worked in the family-owned marine insurance brokering company in Istanbul called GTG for 6 years. Welcome, Ms. Ture. It's our pleasure to have you with us today. Thanks for joining.
Thank you. It's my pleasure. Thank you for having me here in this webinar, along with the respectful participants. I think it's a very interesting subject, and I hope all the viewers will be interested as much as I am and listen to the valuable thoughts of the respectful participants here.
Thank you. Thank you. I think so. And last but not least, Norman Martinez. Norman Martinez read law at the National Autonomous University of Honduras and has been lecturing in international law and maritime law for over 20 years. Since 2013, Professor Martinez has been a member of the panel of arbitrators of the Câmara Arbitral Marítima no Rio de Janeiro, Brazil. Professor Martinez is also a member of editorial board of Benedict's Maritime Bulletin and has published numerous articles in prestigious law journals around the world. Welcome, Professor Martinez. It's a pleasure to have you with us today.
Thank you very much, Sinam. Good morning, afternoon, evening to everyone, wherever you may be. Thank you very much for the invitation. I am truly honored to share the platform with such distinguished colleagues and to discuss this ever-evolving case. We may only touch the tip of the iceberg here because things keep on moving, but we will try to be as brief as possible to highlight the main points. I will address some points on limitation of liability maybe, and perhaps open to any questions that the audience may have. Thank you very much for the invitation.
Thank you to you, Professor Martinez. So great. So as you all see,
I'm so sorry that I cut out my connection cut. So I apologize. I think I was mid-sentence just to say hello, everybody, and I'm delighted to be here.
Thank you. Thank you once again, Jeffrey. So as we all see, we have many experts with us today in their specialized field, and I'm so honored to moderate this webinar with all of them. And now I would like to start discussions by asking the first question to Mr. Sumer. I would like to ask him to give us a little bit short background and facts of every given Suez Canal blockage. So Mr. Sumer, what happened in the Suez Canal and why was it covered so broadly on international media? Thank you.
Thank you, Sinem. As you may recall, Ever Given grounded diagonally across the Suez Canal on the 23rd of March. And this grounding of the vessel and the subsequent closure of the Suez Canal, in fact, reminded me of the history of the previous Suez crisis. Unfortunately, canal had to be closed again for 6 days after almost half a century. And obviously, the reason for this recent closure was different than the previous two Suez crises, although the consequences might be a little similar with regard to closure. And the Suez Canal was built under the supervision of a French diplomat, Ferdinand de Lesseps, and it was opened in 1869 after 10 years of massive construction efforts. And many Egyptians had to sacrifice themselves for the sake of this challenging, enormous task of building the canal. And I think we would all agree that Egyptians did miracles since ancient times with sophisticated structures such as pyramids. And this man-made canal is important because it connects the Mediterranean Sea to the Indian Ocean by the way of the Red Sea. And it is a busy route between Asia and Europe, since it's much shorter than the alternative route through the Cape of Good Hope. In fact, it shortens the time and cost of shipping substantially. And it appears to be that the canal is one of the early examples of globalization as well, which enabled goods and people to move faster in shorter period of time. Therefore, ladies and gentlemen, Suez Canal has great significance for international shipping because it is one of the most important maritime choke points and the key trade arteries. The Panama flag Ever Given was traveling north in the Suez Canal, bound for Rotterdam before grounding happened. And public sources reported that high winds and a dust storm hit the Suez area, and subsequently, Ever Given vessel ran aground. Despite the six-day blockage of the canal, it was good to learn that the crew is safe, no pollution occurred in the canal, and no cargo was lost. Of course, we have to note the massive efforts of Salvage. Finally, on the 29th of March, a flotilla of tugboats, dredge and salvage teams, with the help of high tide, managed to refloat the vessel. International community was indeed attentive to this incident because the grounding of the Ever Given caused considerable delays. Therefore, it disrupted international trade and supply chains significantly. Certainly, the possible causes of this incident have to be fully investigated to settle liabilities. And moreover, it's equally important to prevent any future recurrence in such an important maritime choke point. Although the Suez Canal has opened again after the longest closure since 1975, the legal battle over damage appears to be lasting much longer than the 6 days of the obstruction. And legal ramifications at first glance seems to be enormous, and we will be discussing some of these legal issues shortly. Back to you, Sina.
Thank you, Mr. Sumer. Yes, I mean, the grounding actually, needless to say, that affected the traffic in the both directions in the canal. And in fact, as far as I'm concerned, Lloyd's List also published and reported more than 400 ships that were in the queue. And therefore, within this connection, I would like to shift the question to Mr. Blum. Jeffrey, how was and is commerce affected by the Ever Given incident?
Thank you. Well, certainly, I absolutely agree with everything that Murat has said just now, and it's a wonderful precursor to my little contribution to this conversation. Commerce certainly was affected, and I'm going to highlight a little bit of how, not that it would be a surprise to people, but I'm going to concentrate more on how it will be affected going forward. It was, exactly as Murat said, a major incident. It did, exactly as Lorenzo mentioned earlier, highlight to the public just how important shipping is, and particularly the, as you call it, choke point of the Suez Canal and other canals, of course. Let us not forget where some of you are, the Bosphorus, and of course also Panama. And it brought home to the public in a much more stark way than even than some movies, to Joe public, just how important shipping is. And people generally who are not in our arena don't seem to realize that goods don't just magically appear on the shelves. And to that end, it was very, very useful to highlight what it is that we do, and also the plight of crew on board, partly of course because of the incident, and partly of course because of the horror of the pandemic, and some crew have been on board ships, as I well know from several of them, for up to 9 months, and that is obviously no longer acceptable. So commerce was definitely affected by the approximately, you say 400, I heard it was 350 ships, but anyway, a lot of ships. Not only, of course, other container ships, but also dry bulkers and tankers of varying sizes, with a whole multitude of different types of cargo on board. And again, it's highlighted to the public just how important our profession, our trade is. The fact that some of the owners decided they didn't want to wait, because on day 3 and day 4, nobody knew how long the Ever Given would be stuck with her bow in the sand. and some owners decided to, as we say, bite the bullet, and they went south about via the Cape of Good Hope instead of going north from the Red Sea, or even going all the way back along the Mediterranean, back to Gibraltar and going round the Cape of Good Hope that way, which added between 12 and 15 days to their voyages, with obviously extended costs, including the cost of the hire of the vessel per day, and also obviously the cost of the bunkers, the fuel and the diesel being spent. So that was at a considerable cost, and some of the owners decided to hold off and wait and see, and they were actually rewarded because just 2 days later the canal was opened. Those who took the longer route, obviously that was their own gamble, and I think that those particular owners and operators may well be suffering financially for quite a while to come. How will commerce be affected? Well, that is a much, much wider question. The knock-on effect of all those 350, 400 ships which were waiting to go through either northbound or southbound is enormous, truly enormous. And if we take just the Ever Given alone and ignore all the other ships, she was bound for, and is still bound for, Rotterdam with some 20,000 containers on board. And not every container will be filled with one particular cargo. Of course, there may be multiples, what we call groupage or consolidation cargoes. So you may have something in the region of, I don't know, but I'm guessing something in the region of 1 million different boxes, items of cargo. And when the vessel does finally, albeit very late, arrive in Rotterdam, the cargo is not destined for Rotterdam. Of course, the cargo will then be offloaded and put onto feeder vessels to go from the hub port of Rotterdam to all the little spoke ports around Northwest Europe, including the UK. And also some of the containers will be put onto trains and lorries and taken inland. And some of them will be put onto Rhine barges and taken up the Rhine to Switzerland, and then from there on towards Austria. And so this is really an enormous knock-on effect. And the fact that the goods will, from that particular ship, will be delayed by some 3 or 4 or more weeks is obviously going to affect some of the cargo, which may well be beyond its sell-by date by the time the cargo finally reaches the end user. The other ships may only, those who didn't go around the Cape of Good Hope, may only be delayed for, I say only, it's pretty serious, but only delayed for 6, 7, 8 days. But even that, with a knock-on effect of future employment for the ships and their hinterland connections as well. This is really, really global and massive. And the question why it happened, I'm going to leave to another time. But for now, thanks for listening, and I pass back to you, Sina.
Thank you, Jeffrey, for your comments. So in fact, yes, Evergreen is freed and successfully refloated. And in accordance with the information from UK Pni Club, the ship owners received a claim from Suez Canal Authority for the sum of $916 million to recover losses during the Evergreen's grounding. And the claim includes $300 million for salvage bonus, $300 million claim for loss of reputation. So as the claims also being brought to have exceed beyond $900 million, I would like to ask to Professor Martinez whether ship owners bound to answer for the totality of the claims, what is the limit of the MV Ever Given, and what types of claims would be covered by a possible limitation fund. Thank you.
Thank you very much, Sinem. I think Jeffrey and Murad have done a wonderful start and have set the scene for the magnitude that of this event, the catastrophic real consequences that it caused. We may have seen it a matter of days, but the consequences would be far-reaching. As you pointed out, the Evergreen is being faced with a claim of almost $1 billion. And some of them, and I want to highlight this, is for $300 million for loss of reputation, which is considered a pure economic loss. In principle, the rule is that a person is obliged to make restitution integrum, to pay every last cent of damage that it has caused. But since very early in principle of navigation, there was a concept that was developed that is called limitation of liability. originally established by abandonment, when the ship owner would abandon the vessel and the claimants would settle their claims from the proceeds of the sale of the vessel, it developed in international regulation to a concept of limitation by tonnage. So nowadays, a limit of liability is calculated based on the tonnage of the vessel. So this principle of limitation of liability entails that no matter the amount of the claims, the ship owner would be entitled to limit his liability up to a particular sum. There have been a number of limitation conventions over the years, but the current international legal framework is governed by the Convention on Limitation of Liability for Maritime Claims, or LLMC as is known, of 1976. And it has been amended by the 1996 protocol thereto, which in turn was updated, let me use the word, with the limits of which were updated by a resolution of the IMO Legal Committee in 2012 to keep abreast with the modern limits of liability. Now, the convention not only establishes the right to limit liability, and in Article 1 lists the persons that are entitled to limit liability, but in Article 2, it lists the claims that are subject to limitation. And the first of these claims listed is claims in respect of loss of life or personal injury, and loss of or damage to property and consequential loss resulting therefrom. So this is the key word, loss of or damage to property and consequential loss resulting therefrom. We have to analyze whether the claims that are brought fall within those categories. Another claim, as Jeffrey was pointing out, the vessels that had to turn around or the vessels that had to wait, is claims for delay. That sometimes we speak of delay as concrete loss, which would be when there is the grounding of the vessel, as in this case, and then as a direct consequence, there is a delay. And then you have the abstract loss when there is no loss or damage to property, but there is still a delay. That is also covered by the limitation convention. There are a number of other claims that are listed, but would be relevant for our purposes, like Murad was mentioning, like pollution claims and the like, that did not take place in this case. One point that I want to mention is that when I arrive to the limit of liability shortly, we have to understand that whereas most claims are subject to limitation, the convention expressly lists the claims that are excepted from limitation. And one such a claim is the salvage claim. So wreck removal claims are covered by limitation, although states are allowed to make a reservation thereof, but this was not considered a wreck removal claim, it was considered a salvage claim. And salvage claims are excluded from limitation, so they have to pay it in full to the salvor. And I understand that the salvage claim in this case would be higher than the actual limit of liability. So the ship owner would be able to constitute a fund for the claims that are subject to limitation, and over and above, he would have to pay the limits, the amount owed for the salvage services. Now, the only exception to the rule nowadays of limitation of liability is if the claimants can prove that the loss was suffered as a result of the personal act or omission of the ship owner caused with intent or recklessly and with knowledge that such loss would probably result. And this, in reality, is a very, very difficult test to break. In fact, when the convention was adopted, it was considered as a virtually unbreakable right to limit liability. And this was because the ship owners accepted a higher limit of liability to satisfy the demands of the claimants, but at the same time protecting the right to limit liability. So almost invariably, they will be entitled to limit liability. In fact, there was a case, the Capitan San Luis, where the court actually said that once the ship owner establishes that he's one of the persons listed in Article 1, it is virtually axiomatic that he would be entitled to limit liability. Now, so basically, it's certain, I don't think that it will be questioned in this case, the conduct of Article 4. So we now turn to the limit of liability. The limit of liability, you will realize, has a very big difference between that of the 1976 convention and that of the 1996 protocol. In fact, I found conflicting tonnages. I didn't find the official tonnage of the vessel to do my calculations, but I found the tonnage of 219,079 tons. And I did the calculation of the limit of liability as per both conventions. And under the 1976 convention, it is 22,467,057 special drawing rights, which converted to the US dollar at today's rate based on the International Monetary Fund website, it is $32,185,856. So we're talking roughly $32 million under the 1976 convention. Under the 1996 protocol, however, the limit of liability is $81,563,858, which translated to dollars at today's rate would be $116,846,752. So we can see there is not a substantial, a massive difference between the limits of liability under the 1976 and the 1996 protocol. So in principle, there is an obligation to restitute in integrum, but there is in shipping the concept of limitation of liability. Salvage claims, all the amounts that are due to the different salvors that assisted in this claim have to be paid in full, but any other claims would be subject to limitation of liability.
Thank you, Professor Martinez. I also have a couple of questions later on about salvage matters, but I will come back to later. So in this case, I would like to turn into the Pni coverage. So as we know, while PNR would cover in this case is for the ship owner's legal liability to cargo owner, as far as I'm concerned, they don't cover payouts for delays in these cases or general average. But for having further information in this, I would like to shift the stage to Ms. Torre to ask the position of insurance related with Pni cover, especially in relation with the $900 million claimed by the Canal, which include around 300 million of reputational damage. Thank you.
Thank you, Sinem Hanım. Who kindly mentioned before, I'm a marine insurance broker with PL Ferrari. We place Pni insurance for over 4,000 ships every year, and our experienced claims team deal with all types of incidents, ranging from your ordinary daily cargo claims to complicated high-value claims, such as the Ever Given case. As the participants well mentioned before, despite the ship was refloated after only 6 days, it resulted in a significant disruption in trade and left us with potentially sizable insurance claims. While these significant losses are yet to be quantified, of course, related parties wonder if their losses are in fact recoverable and from whom. Before moving to liability, I just want to quickly remind that the casualty vessel's first-party losses, that is, physical damage to the hull and repairs involved as a result of the grounding, is a claim under the ship's hull and machinery cover, who would also respond to costs incurred with respect to salvage in accordance with the GA, the general average declared. Moving on to the liability insurance aspect of this incident, generally speaking, liability insurers would normally respond to valid third-party claims where owner of the vessel is held legally liable. Having said that, of course, each incident should be examined and judged on its own merits. The vessel's Pni Club, as you said, the UK Pni Club announced that the owners received $916 million compensation demand from the Suez Canal Authority. The breakdown was not provided in the announcement, and the investigation is still ongoing as to determine the cause of the casualty and responsible parties. Nonetheless, the potential Pni claims from the incident would include first, physical damage caused to the canal by the casualty vessel, unless that liability is covered under the ship's hull policy. Now, moving on to the Suez Canal's other demands, in addition to the physical damage. Another claim can be revenues that the Canal Authority lost because of the blockage. Lost revenues are estimated at roughly $15 million a day, so just below 100 for the 6 days in total the canal was blocked. A more striking number you mentioned, according to press reports, is claimed for the loss of reputation. Now, loss of reputation is not expressly included as a risk cover under the rules of IGPNI clause. But this doesn't necessarily mean that it will not be covered. But first, the member has to be held legally liable for such a claim. Now, I would leave the merits of such a claim to the esteemed professionals here, but to say the least, Canal Authority will need to justify their claims. For example, by showing canal bookings have been decreasing since the grounding, and the reason can only be attributable to the incident, to this incident, rather than the usual considerations about deadlines of contracts, contractual obligations, fuel prices, and so on. But eventually, in the end, if courts hold the ship legally liable for loss of reputation and as a direct consequence and for a quantifiable damage, that is, the damage needs to be quantified, then as a legal liability to a third party, this is potentially a Pni claim. The mutual nature of the Pni insurance, meaning they're not profit-oriented organizations, this enables them to be more flexible than profit-making market insurers to provide cover for their members on a discretionary basis. So in that case, the club's board would decide whether to cover this liability and assist their ship owner member. Similarly, the fines levied by relevant authorities and, if permitted by law, will be covered by the vessel's Pni club on a discretionary basis. So this is in addition to, as you were mentioning, liabilities arising from damage or delay to cargo in the case of perishable goods due to the prolonged journey.
Thank you. Thank you, Mr. I mean, I think given the amounts that are involved, it would be difficult somehow also for the Pni insurance to agree to any commercial settlement, particularly as the other participants may be unwilling to contribute on this basis. But I think we shall see this in the near future, further more detail, I guess. And so the blockage of the Suez Canal, as we can see, had massive impacts on the part of the insurance, as well as on the global trade in general. And further, I want to ask the question to Mr. Macchi, Lorenzo, the consequences of the blockage on the contracts, such as international sale contracts, distribution agreements. So, Lorenzo, what kind of contractual disputes are arising from this blockage? We cannot hear you.
Lorenzo, you're muted.
Okay, can you hear me? All right. Yeah, absolutely. Thank you, Sinem. The blockage of the canal has a disruptive effect on the global trade and I would say with a lot of the supply chain as well. And let's consider that the blockage lasted only 6 days. We cannot imagine what could happen in terms of the impact on the global trade if it would have lasted more. Now, let's look, for example, the impact on sales contract and potential disputes between sellers and buyers under an international contract of sales. Of course, we cannot provide a clear-cut answer. We'll try to have a comparative approach across several jurisdictions. In a potential dispute between a seller and a buyer, at first instance, we need to consider the issue of the passage of risk, which has an enormous impact, especially in case of cargo damage or loss of cargo. Let's think, for instance, at the perishable goods on board of the 400 other vessels. And sometimes clients are too focused on the remedies. Can I, jump the force majeure? But before that, you need to ascertain whether or not the risk has passed in the specific sale contract, because the passage of risk determines who suffer the consequences for the delay caused by the ever given accident. So in order, first of all, we need to look at the wording of the contract. This is quite straightforward, but also at the applicable law of the contract. Let's take, for example, the English law. And under English law, if we if the contract incorporates CIF or FOB or CRF sales, Incoterms, we know that the risk passes at the shipment of the goods, more specifically under English law, where the goods pass the ship's rail. However, if we apply other Incoterms, the risk might pass at a later stage. For instance, in a DAP or DDP, the risk passes when the goods are made available to the buyer at the agreed place, at the agreed destination. However, let's keep in mind that where Incoterms, under English law, where Incoterms are not incorporated, the default position under the Sale of Goods Act in 1979 is that the risk passes when the property passes. So we need to look at the rules to see when the property passes and then the risk passes. Can be when the contract is made, or in case of unascertained goods, when the goods are appropriated to the contract. Anyway, just we can detect few scenarios, whether or not the Incoterms are incorporated, which Incoterms dealing with the passage of risk. Let's look at the international conventions, Convention of Vienna, to the extent that this applies to the contract of sale. The risk passes by default to the delivery at the first carrier. And of course, unless otherwise agreed by the parties, by incorporating other Incoterms. But, and this is quite surprising, if we don't have to look too far, but we can see that local laws deal with the passage of risk in a very different way. Let's look at Italian law, for instance. The Civil Code provides that the risk passes at the delivery to the carrier. Fair enough, straightforward. This is the default position unless there is a specific clause in the contract with clear wording, which specifically deals with the passage of risk. Again, so far so good. But the fact, the mere reference, the mere incorporation of an Incoterm is not enough to derogate to this default position. I know it might sound surprising. This is, for instance, the difference with the Vienna Convention I mentioned before. This is because under Italian law, Incoterms are considered merely expenses clause and not delivery clauses. So they don't deal with the passage of risk. According to the Italian case law, Incoterms are provisions relating to the economic impact, the cost of transport. There are plenty of Italian Supreme Court judgments affirming this principle, which is, in my humble opinion, a little bit uncommercial, to say the least. Anyway, so the passage of risk is always governed by the rules of the Civil Code. That's to say, it passes at the delivery to the carrier. And if you want to derogate this default position, you need a clear wording in the contract and not a mere incorporation of Incoterm. So that was a way to say, let's look at the governing law for each specific contract to see, who bear the risk of the delay of the perished goods after the casualties. Another issue, the classic one, is the issues related to non-performance of the contract. The seller cannot perform his obligation under the contract of sales due to the delay related to the blockage of the canal. The core issue is always the same, where the client comes and say, well, I want to be excused from performing the contract. Can I invoke force majeure? Okay, let's look at this again with a comparative approach. We can draw a clear distinction between common law system and civil law system, and let's say specifically Italian law and English law, as I'm a little bit familiar with both. Under Italian law, the Civil Code provides that if a party fails to perform the contract, the obligation of the contract, and this failure is due to a cause not imputable to him, then the non-faulty party is excused for this failure. It follows that where the contract is governed by Italian law, you don't need a specific force majeure clause. I mean, it's highly recommended to have one, but you don't need it. So the test to be passed is always, the event is extraordinary, unforeseeable, beyond the party control, and there is, of course, not negligence of the party who invokes this remedy. On the other side of the spectrum, under English law, you do need a clear wording in the contract for force majeure. You need a force majeure clause, and this needs to be drafted in a way that deals with that specific event. Actually, there is also the doctrine of frustration, but let's leave it aside, as it's also the frustration rarely see the application before the Court of England. So anyway, in conclusion, very general terms, I might have a remedy implied by law if my contract is governed by Italian law, let's say. On the other hand, I need a clear wording, a specific force majeure if my contract is governed by, for instance, by English law. Thank you.
Thank you, Lorenzo, for the clarification. And the next issue that falls for consideration, actually we were mentioning this before, but the issue of general average. As we know, owners of the vessel had declared general average following the incident. And so as we also know, general average has very ancient roots and romantic, I would say. Just allow me a brief existence. The origin of this body of rules traced back to Lex Rodeo, so back to 4th century, I guess. So the principle is simple, right? Which is given for everyone should be contributed for everyone. So parties of a maritime adventure should share the financial consequences of an unexpected casualty. For instance, jettisoning the cargo to lighten a ship. So in this concept, I would like to ask Jeffrey, Jeffrey, do you think general average was the correct mechanism to use in this case? And I also want to ask you, so we understand also, I think Mr. was mentioning the investigations are ongoing still as the cause of the incidents, and which may be a combination of weather conditions, engine failure, and other causes. It does appear that the vessel was at a higher speed than allowed under Suez Canal, but given that pilots were on board the vessel and that the Suez Canal Authority would have been monitoring the progress of the vessel, I have also the second question. I would like to ask you how the Suez Canal Authority is coping with that matter. Thank you. Jeffrey, you need to unmute yourself.
Sorry about that. Yes, those are two major questions, and I'll try and tackle them separately. So the first question you are asking about general average and whether it indeed should have been declared. As I'm sure we all know, if the owners are going to declare general average, it must be done pretty quickly after an incident. They can't wait for 4 or 6 months and then decide that they want to declare GA. One of the big questions, therefore, is the other types of insurance which may well be involved. We're talking of a multiple Pni cover. Of course, Elif has already referred to that. One of the big questions for the lawyers in the legal teams in the Pni clubs, who will no doubt be helping many of the parties who are involved, and we're talking multiples, as I said before, some possibly 1 million parties in 20,000 containers, many of which will not be full container loads, but groupage or consolidation loads. So just 5 or 6 boxes of widgets in each container. So we're talking of multiple parties. Which law might apply? And also, I don't think it's yet been established which of the York-Antwerp rules would apply. I believe 1994 has been mentioned as the most likely, but there are, of course, at least 2 others, one earlier and one later than 1994, although that is usually the favored set of rules. And also, exactly as Lorenzo has mentioned just now, which type of law might apply to the various claims. Would it all be under English law? Perhaps not, may well be not. But before I come on to, excuse me, how the Suez Canal Authority is coping, I'm going to spend a little bit more time on this first question, whether GA is the correct procedure. As I've just said, I think it is, let me start again. If the owners were going to declare GA at all, then now is the time to have done so. They can't wait. Whether it's the right thing to have done will be open to very many questions. For GA to happen, extraordinary expenditure must have been incurred, and certainly that is true, and or sacrifices incurred. And to some extent, that may well also be valid, but certainly expenditure for sure. In that sense, the definition under York-Antwerp rules, Rule A, of what is GA has, it seems, already been met. However, one of the big problems with such a mega beast of a ship is that she is so darned high that it will be extremely difficult, if not, some people say impossible, to start taking some of those containers off the weather deck and transposing them onto smaller ships in the Great Bitter Lake, where she is still currently under arrest. And that is frankly not going to happen because most of the floating cranes aren't tall enough to be able to take the containers from the top layer, and they're some 33 meters high, which is one of the reasons why the ship drifted, because there was a huge sail, a wall of metal, which was met by this 50-kilometer-per-hour wind. And that was one of the reasons why the vessel foundered. Alleged blackout as well, lack of electricity, going far too fast, as you mentioned, Sinem. She wasn't the only one, of course. The convoy was going at something in the region of 13 knots, which is much faster than the usual 6, 7, or 8 knots going in. And I know this also because one of my current students is a second engineer on a vessel that had just left the Suez, coming out down the Red Sea, as one of his colleagues was going in, and the colleague is one of the engineers on the Ever Given, and I therefore know that she was going far too fast to speak. Why is another question, and that will lead me shortly onto how the Suez Canal Authority is coping, and they will have multiple claims, I suggest, against them. There may well be counterclaims. I would think many of them. To stay with the GA idea, whether that's the correct procedure, there are quite a few ways of getting around this. One would be to keep the vessel under arrest, including, unfortunately, the crew, until the matter has been resolved, and who knows how long that might be. If we think about the Hebe Spirit, I think the Indian crew were on board for over 520 days, which is pretty horrendous. And I hope, of course, that won't happen to the crew of the Ever Given. It might be possible to take or in fact necessary, to take the vessel in tow, of course, through the Great Bitter Lake, going north to Port Said, where there is a big container terminal, where those containers could then be offloaded and possibly put onto other vessels, then to continue their voyage to final destination Rotterdam, and then on carriage to elsewhere, even if the Ever Given herself then has to stay under Egyptian arrest in Egyptian waters in, for example, Port Said. It doesn't have to be in the middle of the Great Bitter Lake. So that is one possibility. And I've heard quite a few people talking about this, and it strikes me as eminently sensible as a practical solution. One of the other problems, other than GA, is of course the hull and machinery insurance, the various types of P&I insurance, which Elif already mentioned, the charters P&I insurance as well. Let's not forget, charters have their own P&I cover, and they may well need to invoke that. It's not only the owners who are, of course, at the sharp end of this, and obviously all the cargo insurers and their values, the values of their cargoes, which may well go down, and in some cases go down considerably if the arrival of the cargo of perishable goods means that the cargo is effectively unsellable, and then you have a much bigger claim on your hand, rather than if it's just concrete blocks or steel or cars or whatever else the cargo might be, which doesn't have a short shelf life. There may, of course, also be a counterclaim, and this may well be against the Suez Canal Authority themselves. There is quite a lot of talk in the press, and I've read a number of articles and spoken to a number of colleagues, whereby is the Suez Canal coping, which is your second question to me, Sinem. From what I keep hearing, it may well be that the Suez Canal is putting up a smokescreen blaming everybody else, instead of taking responsibility for their own failings. One has to ask the question, and no doubt this will come out in very thorough investigations. What were the two pilots, Suez Canal pilots, doing on board? Yes, she is a big beast. Yes, she went in far too fast. She went in not alone, of course, she was in convoy. Why was the whole convoy going through so fast? There is already proof that she was hanging around outside, and she and others, but the Ever Given in particular, was doing all sorts of figure of eight maneuvers outside El Suez before she went into the canal. Why? And did she have to make up for lost time? In which case, was she the prime mover in speeding up the rest of the convoy who simply followed her? Were the Suez Canal pilots instructed to push forward at greater speed than was safe? They are ultimately in control. Yes, of course, the master has the final say, and there are all sorts of legal arguments both ways. And I think that the Suez Canal Authority themselves, far from, rather than claiming $300 million of loss of reputation, I think they may well have lost their reputation by their own doing, rather than because of somebody else's doing. One other matter I'd like to bring to your attention, which is something that was brought to my attention about 2.5 hours ago, so it's pretty fresh, is that there is now quite a lot of good, serious discussion as to how the Suez Canal might benefit from this incident by learning from it and thereby making a slightly, we'll call it, innovation move. In other words, they would change the way that the Suez Canal Authority works, and obviously all the users. It is one of the major canals in the world, and I believe something in the region of 12% of all trade goes through the Suez, which is pretty important. So one of the ways that the Suez Canal might be forced to change would be to have better planning tools for congested areas and greater control as to what they do and when they do and how they're going to do this, rather than having a bottleneck of ships. There may well need to be much more of a rigid, I'll use the word structure in place. There may well be a whole new structure of using berths and canals, and therefore staggering the number of ships that go through at any one time. There is still the convoy that is still necessary, even though the Suez Canal was widened within 1 year in 2016. And it is certainly wider than it had been, for sure. And the Egyptian army was very good at being told what to do, and they just got on and did it. And they finished everything in 1 year, which is from which the Panama Canal engineers might learn a lesson or three. But the point is that smaller ships can therefore pass each other in the northbound and southbound convoys, but the bigger ones can't. And therefore, a big beast like the Ever Given still has to go up in solo convoy until it can be passed or can pass other ships in the much wider, of course, the Great Bitter Lake. So maybe greater planning is required for the Suez Canal to learn from this, and perhaps then this kind of an incident may not happen again. Who knows? None of us can foretell. There may also be a new idea of using AI, as in artificial intelligence and algorithms and so forth. And I've heard talk of rather like sending a virtual notice of readiness to a port, rather than the vessel physically having to be at the port or in the area controlled by the port authority. There is now talk of having virtual arrival at or off the entrances, north and south entrances of the Suez Canal, and basically booking your space, booking your slot, which may indeed be quite a useful tool to use. So those are some of the ideas. I wanted to ask Norman quickly, because of you were talking about liability, limitation of liability, and I wonder whether, and I'm hoping you agree with me, whether one of the big questions that's going to be asked is, will everybody start looking much more carefully at the Hague-Visby rules, and most especially the Hague-Visby rules Article 4(2)a, whereby it seems to be the opposite of Article 3, as in seaworthiness and properly manned, equipped and supplied and so forth. Because, as I'm sure you know, and many people listening will know, the Article 4 of the Hague-Visby rules is effectively the get-out, the excuse clause, if you will, the article that gives lots of reasons why the owners are not liable, and that leads straight back to what you were saying earlier, Norman. And I really wonder whether management of the ship, which of course is mentioned in Article 4, Rule 2 little a. Other than navigation, the main key word in that little subclause is management of the ship. And I wonder whether the ship was actually mismanaged. Never mind the navigation problem, which I've just highlighted, but I think that the navigation of the ship, both on board and also ashore, and possibly with the assistance of, or lack of assistance of the two, I repeat, two pilots of the Suez Canal Authority, I think some serious questions might well need to be asked, and at the risk of being slightly comic, and I will bring my little ideas now to a close, but I just wanted to say that this incident is going to run and run for not months but years, and I think that there may well be new rules coming into effect, not only in the Suez but also regarding liner shipping. Certainly as regards tramp shipping, I think that some of the clauses in charter parties may well need to be changed, for reasons that the others who've talked so far have already mentioned. And I think that as an expert witness, as I am, and also as an arbitrator, as I am, and also for lawyers working for law firms and the Pni clubs and everybody else involved in all of this, I believe that this incident is going to run and run, and might even be said to be the gift that is ever giving. Over to you, Sinan.
Thank you, Jeffrey. Professor Martinez, would you like to go ahead and quickly answer Jeffrey's question?
Yeah, yes, in fact, I had made an annotation so that I would cover that when it was my turn. But yes, certainly, Jeffrey, I think what I was discussing before was the concept of global limitation of liability, that concept that the ship owner does the maximum exposure that it may have vis-a-vis all the claimants, the aggregate of all claims. But certainly, the point that you raise is essential, because in fact, it is the starting point of any claim. As you said, there thousands of claimants that would bring claims against the ship owner, and they would be bringing their claims based on their bills of lading, and therefore the Hague-Wisby rules would be the starting point of those small claims. We would have to determine whether they are subject to limitation or liability, as you rightly point out. I mean, that would be a very factual thing, and it will depend as well, not only, and this is the funny thing, that one thing is what the drafters of the conventions intended when they drafted. Another thing is what the text of the convention actually says, and a completely different thing is how courts interpret it. So it will depend pretty much as well on which countries would is subject to the bills of lading, what is the governing law of each bill of lading, and that will be the starting point. And once those claims are limited in turn by the Hague-Wisby rule, the aggregate of all claims may be subject to global limit, adding to the Canal's claims, etc. But yes, going back to your question, in fact, that will be not only a possibility, but it will certainly be the starting point of the discussions. One may say that when the Ever Given is faced with these claims, it is possible that if it is recognized that liability would be eventually be found, that perhaps a settlement option would be in order. But certainly, any settlement would be on a prospect of liability and money. And money. So yes, certainly the starting point of any discussion, insofar as the claims of the containers on board, would be the Hague-Wisby rules or any law that governs any bill of lading. On the other hand, external claims like those of the Suez Canal Authority, etc., will not be subject to the Hague-Wisby rules and will be subject to any national law or international convention that may be enforced, and they will all meet when they discuss the global limit.
And we haven't, if I may just quickly add one thing to that, just very quickly, we haven't even touched on the multiple claims which are bound to come from the owners of cargoes and the owners of ships carrying those cargoes of the other 349 ships which are involved. And that is going to really run and run for a long time to come.
Absolutely.
Absolutely. Thank you, Jeffrey. Perhaps, as you said, also for the, let's say, cargo insurance parts, the only recourse for the cargo owners is to, at this stage, to work diligently with Pni Insurance, UK Pni Club, since any damage to the cargo under the bill of lading issued by the vessel is an exposure to UK Pni Club. And on this point, I would like to ask further to Ms. Torre, generally speaking, how does the insurance market and also reinsurance market deals with such claims? So how the risk is apportioned between UK Pni, the pool of Pni, reinsurers, and what do you think generally is going to be the impact of that blockage on the Pni market? Thank you.
Thank you. Of course, this incident, involving one of the world's largest vessels blocking one of the world's busiest waterways, is a significant event for the marine insurance sector. As already established, I think, estimates on the quantum of potential claims, yes, there are figures in the north of $1 billion, especially when the Suez Canal Authority made its claim against the owners of the ship. But I would start by being cautious so as to say that it may still be early to make assumptions before, again, liability is established and the quantum of the damages are more concretely placed. So far as the quantum of the event, the ship itself doesn't have had a big bad damage, so repair fees may not be huge. A rather big ticket item that we were discussing will be presumably the cost of salvage operation, and as esteemed professors were mentioning, the owner declared a general average. There are legal issues around that, first of all, but generally speaking, those costs will be jointly covered by the vessel's H&M underwriter and cargo insurers or cargo owners if they don't have cargo insurance. And unrecoverable GA contributions are covered by Pni. So how all these, when the quantum is clearer with lots of claims in the line, how these demands will be met? From the point of Pni, regards to dealing with liability claims, each of the 13 IG clubs retains the first level of an individual claim up to $10 million currently. So the first 10 million is on the club who insured the liability insurance. If the claim exceeds that retention level, it is then pooled amongst all of the 13 IG clubs in a pooling system. And this is for claims over 10 million and up to $100 million. This will be shared between the 13 member clubs. Excess of that, over 100 million, is substantially reinsured in the reinsurance market. Similarly, H&M insurers typically would reinsure some of their risks, and so do cargo insurance. So this event is not rare, is a rare event, not an everyday incident, but it is a fact that world fleet and capacity of megaships are ever growing, so to be economically feasible and more competitive. This was a fortunate event, evidently, in the sense that the canal was cleared relatively in a short time, and the vessel and the cargo seems to be not badly damaged. So in a sense that things could go worse, but it is very indeed a good reminder of how things can potentially go wrong, and certainly a concern for all the insurers involved, cargo insurers, hull and machinery insurers, and of course, not the least, liability insurers. And this event comes at a time when the insurance market is in a hardening cycle, both on the H&M side and on the Pni insurance side. Ship owners attending this webinar or other esteemed colleagues may be well aware that recent years we saw big casualties, big marine casualties such as the Golden Ray, Costa Concordia, and so on. So these big claims are growing costs for Pni clubs who have been needing to increase their rates to balance their income against cost of large claims like these. Now, by their nature, as I said, clubs are not aimed at making profits, but they should also cannot sustain losses every year, one after another. So ideally, premiums collected plus any investment income should balance the claims roughly. To cut a long story short, these big casualties are adding on to the costs that Pni clubs need to face. So, and the Ever Given incident is another potential big case with a potential to hit the reinsurance layer of the structure. The IG clubs, as I was mentioning before, over $100 million, reinsure their risks. And their current contract was a 2-year placement secured back in 2020. So this year, there was no renewal on that contract, and the group was still able to provide price stability to their members, where market rates are increasing double digits. But at the next renewal in Feb 2022, it will not be surprising if we find reinsurers looking to re-rate and cover these 2 years of market increases and also factor in new big claims kicking in. Another maybe point of interest would be that under this scheme, this program, the reinsurance costs are shared between different types of vessels, which are rated individually. And fully cellular container segment was introduced this year before this event in February 21. So it may be fair to say that the owners of cellular containers may be affected more from this expected increase in reinsurance rate, just was in the case of Costa Concordia. After that event, the passenger vessel rates increased more than the other segments. So overall, I guess I can say that market is already hardening across the board. And this is a reminder of another potential risk, this time involving the box ships. And after this event, there may be particular focus on risks associated with these types of vessels.
I agree, Mr. Thank you. I mean, in fact, the effect on the global chain due to the incident has resulted at first in insurance claims, but the claims actually will not come only from cargo on board the Ever Given, but from cargoes on ships, which voyage will be delayed due to inability to transit the canal as well. I think Jeffrey was mentioning before. And many of the ships, as also all of you were mentioning in your discussions, faced a difficult choice in waiting, as the alternative route through Cape of Good was a longer and costlier voyage. And also some ships, they began to divert around the Cape. Jeffrey was mentioning that I think 6 to 8 days added to the typical voyage duration. And in that connection, I would like to ask further Lorenzo with the connection of this question, what can be the impacts of this on the charter parties in place?
Yeah, thank you. Well, can you hear me? Yeah. Well, indeed, we are experiencing disputes between charterers and owners of the ship delayed by the Ever Given incident. In particular, cancellation rights or claim for damage. So let's try to give an overview of the disputes which may arise under existing charter parties. Of course, let's distinguish time charter party and voyage charter party. Let's start with the time charter party. We can spot 3 essential moments. The delivery of the vessel. Second moment is when the vessel has been delivered to the charter, right? And third, the redelivery of the vessel after the charter party end. So looking at the first essential moment, looking at the delivery of the vessel. First question, can the owner be exposed to cancellation? first answer. The answer is yes. The owner is potentially exposed to the risk of cancellation if the laycan is not met. And this is simply because the owner bear the risk and the expenses to get the vessel on time at the place of delivery. Then the vessel has arrived. Second question, can the time charter put the ship on fire? Well, my opinion, I do not see how the charter can put the ship on fire due to the delay caused by the Suez Canal, at least looking at the standard charter parties. And the answer is, the reason is simple, because the delay has nothing to do with the vessel itself, but depends on something which is beyond the control of the owner. Our conclusion would be totally different in case, for instance, of a breakdown of a vessel. So speaking about deviation, the charter might have ordered to wait in the waiting area for the canal to be freed, or might have ordered to deviate from the route, and some of them did, from the Cape of Good Hope. Anyway, in both cases, the vessel is at the charter order, and the charter is obliged to pay higher in full, as well as the fuel and the operating expenses. Of course, I'm talking about standard charter parties, and if there is a wording to the contrary in the charter party, then the situation would be different. Third phase, redelivery, the charter also will bear the cost of the late redelivery of the vessel, and which cost and how much? Well, we need to look at the market rate after the redelivery date. So if the market went down, then the damage for the overrun period will be the charter high rate. If the market instead is higher, then the damage will be the market rate. It's quite straightforward. Let's have a look at the position under a voyage charter party, which is totally different, of course, because all the extra cost that save additional time spent by the vessels, additional cost incurred, operational time, fuel, and so on, are borne by the ship owner. The question is the charterer entitled to cancel the ship if the vessel doesn't arrive on time? Yes, it seems quite straightforward that the charterer is entitled to cancel the charter party if the laycan is not met due to the blockage. However, the fact that the owner does not arrive within the cancellation due date doesn't automatically give rise to the right to claim damage against the owner. And very often I see a lot of confusion, so I jump the gun of the lay time and then I claim for damage. There is a bit confusion between cancellation and request for damage. The charterer can only claim for damage in the event of a breach of charter party. And the fact that the owner doesn't arrive on time is not per se, it's not itself a breach of the charter party. This is because under English law, basically, there is no an absolutely obligation for the owner to arrive on time. If it doesn't, simply the charter can cancel. That's it. There is another obligation instead of the owner. The owner is obliged to commence the approach voyage within a date when it's reasonably certain that the vessel will arrive at the port of loading by the cancelling date. There is a leading case in England, it's the Pacific Voyager, Court of Appeal 2017, which deals with this topic, the commence of the approach voyage, and which is an implied condition at English law. So to establish a breach, we need to ascertain whether or not the owner commenced the approach voyage on time. Another condition under English law is the one to proceed at the port of loading or the port of discharging with the utmost dispatch. It doesn't seem to be the case to me in these specific circumstances, because I doubt that the owner can be considered in breach of this condition, as the ship was actually unable to transit the canal, physically unable due to the blockage. So there would be many issues and things to talk about, but that was a little wrap up for some of the charter party issue that we are experiencing and that we will experience in the near future. Thank you.
Thank you. Thank you, Lorenzo. We have already receiving questions in the Q&A session, Q&A part, but I will take all the Q&As once we conclude our session. So I will try to take all the questions and address to the speakers. I would like to now come back to Norman Martinez. Also, one of the questions is actually related with this that we have in Q&A. So we understand also that Egypt is a signatory to the Shipowners Limitation of Liability Convention, I guess, which entitle owners to limit liability based on the tonnage of the vessel. It was said before, but Suez Canal Authority rules explicitly prohibit the invocation of such limitations. So Professor Martinez, also based on the question that we received on Q&A, where does a limitation fund have to be constituted, and do other states have to respect that fund?
Now, thank you, Sinem. This is not only a very interesting question, but a very controversial one at the same time, because when you find the dispute, the lawyers would be staunchly supporting opposing arguments. Truth is that every state is sovereign and is entitled to rule its territory by its own laws. And it is only limited in international law when it is a rule of customary international law, which usually is on the public side of the law, not in limitation of liability, or when it is treaty law. So if a state has acceded or become a party to a particular international convention under the Vienna Convention on the Law of Treaties, it has an obligation, as they said, pacta sunt servanda, to comply the treaties in good faith. And non-compliance of a treaty can bring about international responsibility. So a court cannot ignore a commitment that a state has made under international law. Now, I mentioned this is curious because the 1976 convention, first and foremost, allows limitation of liability without constituting a fund. So you do not need to put an LOU, you do not need to deposit the cash, but once you get a limitation decree, you will know how much is your limit of liability. But if you are to constitute a limitation fund, Article 11 provides that any person alleged to be liable may constitute a fund with a court or other competent authority, and I emphasize here, in a state party. You know, in two things I want to highlight here: in a state party, and second, in which legal proceedings are instituted in respect of claims subject to limitation of liability. In other words, the principle which originated this concept goes back to limitation of liability as a defense, as a shield, not as a sword on the hand of the ship owner, but to protect itself. You know? So basically, it was as a defense. In other words, the ship owner was sued and he would abandon the ship. That's how it started. Now, when the drafters of the convention adopted this text, that also was the intention, that when the ship owner is sued, in that court, the ship owner would constitute a limitation fund. That's why it says in the state party where legal proceedings have been instituted. There is, however, authority in England that a ship owner can do what they call a preemptive strike. And even if he hasn't been sued, he would have a right to invoke limitation of liability. The question is, to what extent is that right, you know, available? Is it an unfettered right, or does it have its own limits? It's itself. And the truth is that it's not an unfettered right. And the ship owner would indeed be entitled to choose a jurisdiction if it does not affect the interests of the claimant. Now, in this particular case, there is a multitude, as Jeff was pointing out, there's a multitude of claimants, and there will be multitude of jurisdictions, particularly as he was mentioning, if there's a bill of lading here, if there's a charter party there, as Lorenzo was saying right now, I arrived late in my charter party because I was delayed because of the Ever Given. So there will be dozens, if not hundreds, of jurisdictions that may see particular liability claims. So where can the ship owner invoke his right to limit liability? And in truth, it would be in any respect. Before answering that question, what is the benefit of constituting a limitation fund? After all, you will not pay a claim until you are found liable. But until that happens, the ship can be sold, the owner may disappear, and the claimants may end up holding a paper of a judgment saying that they are entitled to X amount and they have nowhere to execute the judgment. So the claimants need security. And the most usual way of obtaining security is arresting the vessel. And this is what Egypt did, arresting the vessel. However, in the case of Egypt, from the news I have read, it said that they will not release it pending the payment of the $900 million. And that, to a certain extent, would be contrary to the obligations under the 1976 Convention, because Egypt is indeed a party to the 1976 Convention, which, as I mentioned before, would entitle it to basically $32 million. So once a limitation fund is constituted, the ship arrested may be released. It says emphasis on the word may be released, but it shall be released if the fund is constituted in the place, in the port where the ship was arrested, or the first port of call thereafter. So technically, the obligation would be to release the ship upon constitution of the fund, let's say in Egypt, but that would imply a limitation fund of 32 million. Ship owners, however, may be facing claims in other jurisdictions that are party to the 1996 protocol. So as a result, in April, there was a limitation action instituted in the UK, which the UK is a party to the 1996 protocol. Therefore, the fund with the ship owners will constitute would be in the region of $117 million. As I said, this would not cover claims for salvage and the like; those are excluded. But the question that that ship owner can constitute the limitation fund in any jurisdiction that he is sued. So that could be Egypt with its low limits, or the UK with its high limits. So the ship owners chose the higher limits and to constitute the limit, to invoke the right to limitation of liability. The question, another point that I wanted to mention, which is very important, as Elif was mentioning before, is not about what you ask the court. In fact, the convention says that the fund will be distributed according to the established claims. In other words, the courts have to recognize your claim as valid to be able to be entitled to participate in the fund. That is another thing that the claimants have to bear in mind, because some countries may not necessarily recognize a claim for pure economic loss without a corresponding loss of property, loss or damage to property. So that is up to the claimants to choose where they will sue. But if the claims are recognized, then they can participate in the fund. Now, can Egypt participate in the UK fund? They certainly can, if they voluntarily submit themselves to the jurisdiction of the court. So the ship owners did, let me say, the responsible thing, and constitute or invoke the right to limit in the higher limitation fund. So those states that are parties to the 1976 convention may choose to bring their claims against the fund and proceed there. An alternative could be for the ship owner, if he believes that there is a state that perhaps unwisely may choose not to do that and stick to their guns to a lower limitation fund, may request the court to set aside a part from the fund in relation to payments that may be done elsewhere. The problem arises a contrario sensu, actually. If the ship owner would have constituted a limitation fund under the 1976 convention and then sought protection in a 1996 protocol state. Now, there are many lawyers that believe that that would be the case. And often cited is a case that says that limitation of liability is good against the world at large. But the words that were chosen to express that sentiment was to the world at large insofar as it shares the same limitation of liability concept. So imagine that you are sued in a country that has jurisdiction and has no limitation of liability. Why should you impose the limit on that country if it has chosen not to become a party? Or imagine a country that has chosen not to become a party to the 1976 convention because it has too low limits of liability and has therefore become a party to the 1996 protocol. And then another country which voluntarily acceded to the 1976 convention seeks to impose its law on another sovereign state, which would not necessarily make sense. There is a recent case in Hong Kong that was decided this year. It was the CF Crystal and the Sanchi, where the court actually said that a constitution of a fund in a 1976 country is not a bar to institute proceedings in a 1996 protocol. And there is also a doctrine that would more and more support the idea that a higher limitation country would not necessarily be bound by the lower limitation country. In fact, we don't need to go too far as to discussions, philosophical discussions. The Vienna Convention on the Law of Treaties simply explains as pure and simple that a treaty has no effect on third parties unless they voluntarily agree to them. And the 1996 protocol in Article 9, paragraph 2 expressly says that the protocol shall not bind states parties only to the protocol by the terms of the convention in relation to states that are only parties to the convention. So this provision that I mentioned, that a claimant or a ship owner can constitute a fund in a state party, was not amended by the 1996 protocol. So that remains valid. In short, basically, the ship owner would have been able to constitute a fund in a 1976 state, but that probably would not have been recognized in a 1996 state. So they chose to invoke limitation on liability in the UK, where the limits are the higher limits. Now, other claimants would have to come to the UK to participate in the limitation fund. And I think that answers also the question that was raised in question and answer. Okay.
I think so. Thank you, Professor Martinez. I think you exactly answered the Dr. Saxena's question perfectly. So yes, also you were saying before, and you were pointing out also in your discussion, the convention exempts salvage or general average from limitation. And we know that in the ever given case, owners of the vessel engaged Nippon and Smith Salvage for salvage under law. So I would like to come back to Mr. Sumer for this. Mr. Sumer, could you please tell us about the salvage operation that is conducted and its legal implications? How can we assess the salvage reward in this incident? Thank you.
Thank you, Sinem. Salvage is one of the major issues, obviously, in this incident. So please bear with me as I try to analyze the matter. Like general average, as you have noted, a claim for salvage is also a very ancient right. And salvage is defined as right in law that arises when a person acting as a volunteer and without any contractual or other legal duty to act preserves at sea any vessel, cargo, or other recognized subject of salvage from danger. And until recently, salvage has always been based on the no cure, no pay principle. And if you fail, you are entitled to nothing. But if you succeed, then you may be rewarded generously. Today, salvors are also encouraged to prevent and minimize damage to the environment as well. And the Ever Given, which is one of the largest container vessels in the world, reportedly was almost fully laden with goods during the grounding and the following salvage operation. And there are certain essential ingredients of salvage, namely to be volunteer, to preserve or contribute to preserving a recognized subject of salvage, and lastly, there must be some element of danger, although it doesn't need to be imminent. Ladies and gentlemen, all of those requirements appear to be met in the Ever Given incident. For 6 days, we have witnessed the massive effort of a multinational team of salvors, tug operators, and the Suez Canal Authority coordinating, in fact, a race against time to refloat the Ever Given and open, maybe more importantly, the canal back to international commerce. And for this challenging salvage operation, As Sinem noted, owners have engaged Smith and Nippon Salvage jointly and reportedly on LOF terms to assist the Canal Authority in freeing the Ever Given vessel. So in this incident, there was a combination of numerous tugs and dredgers were engaged in the salvage operation jointly. And reportedly, again, at least 13 tugs worked together to refloat the Ever Given. And furthermore, a huge volume of sand was removed by dredgers from the shoreside. And I have to note that Egypt is party to the 1989 Salvage Convention. And in this incident, the applicable law is the 89 Salvage Convention. Under Article 13 of the convention, the salvors need to achieve a useful outcome for a salvage reward. With the terminology of the previous convention, a beneficial outcome. And in this incident, we see a useful result was achieved by the engaged services of the flotilla of salvors. So in this incident, there is no doubt that we can establish a successful salvage operation was indeed performed. And indeed, the vessel and cargo were preserved quite promptly. And according to public sources, the Canal Authority appears to be seeking 300 million USD salvage remuneration regarding their tugs. Again, under Article 13, each owner is proportionally liable for the ultimate salvage remuneration. But now I'd like to come to the second part of your question regarding the assessment of the actual salvage reward. Salvors, upon the property being salved and brought to a place of safety, is entitled to recover salvage reward, but not exceeding the value of the property salved, assessed at the date and place of the termination of salvage services. And in this incident, the ultra-large container ship is taken to Great Bitter Lake, which can be considered the safe anchorage. LOF does not specify a monetary amount for salvage rewards. Actually, it is the raison d'etre of the form. And under this form, the amount of salvage reward is determined by arbitration, but by applying the some 10 different factors stipulated in Article 13 of the Convention. And in this incident, relevant factors include the value of the property salved, which of course, in this incident, quite large. And the greater the value, the greater the salvage award may be, naturally. And another criterion is the skill and effort of the salvors, the equipment and personnel employed, the actual danger involved in the case. And clearly, the time used is also relevant, since a salvage operation, which can be concluded in 2 hours, does not justify as high as one which reasonably takes 6 days, as in the case of the Ever Given. All the elements set out in Article 13 need to be weighed in the balance when making and determining the award, which should be both encouraging to salvors, but at the same time, also it needs to be just and fair to the salved property. So there are different interests in this incident. The industry case can shed some light on how we should determine the salvage reward in this incident. In the industry case, it was held that the amount of remuneration must depend on all the circumstances. It's not a mere question of work and labor, not a mere calculation of hours. Though time is undoubtedly an ingredient, but there are various facts for consideration. And when all these things are considered, there is still another principle: to encourage enterprise. reward exertion and to be liberal in all that is due to the general interests of commerce and the general benefit of owners and underwriters, even though the reward may fall upon an individual owner with some severity. So the law of salvage has long been recognized as being in the public interest. So it is obvious that the idea is to be generous, but it has to be assessed by weighing in the balance of several criteria that I have just mentioned. To encourage salvers to carry out similar salvage operations, again, in the future, whenever and wherever needed. And so the salvage reward should be determined in a way that would be encouraging for future salvage operations as well. However, I would like to note that the assessment of the salvage award is not simply a mathematical calculation of the time and cost involved. And it is certainly more complicated than that, because it's not a mechanical process, and it's a combination of various factors which needs to be weighed to reach a balanced result in each different case. I would also like to note that under Article 13, the reward cannot exceed the salved value. So that's why salvage reward is not considered in limitation of liability regime in the first place, because the value of the property salved is the practical limit of any salvage reward. And in fact, in practice, arbitrators or courts never make awards equivalent to the complete salved fund. They avoid doing so. Archbishop opines that, as a matter of principle, something has to be always left to the owner while assessing the salvage reward. Otherwise, the owner would have no incentive to seek salvage assistance. And indeed, rewards of a very high percentage of the value is in practice comparatively rare and usually only occurs when the salvor's expenses are extremely high. Until now, statistically speaking, it seems that the highest rewards for salvage were around 2/3 of the salved value in total. But those examples are absolutely exceptions. According to Lloyd's, the average salvage reward is around 11 or 12% of the salved value. But of course, as I have noted earlier, every case is different. And the determination of the salvage reward in the every given incident is not a simple calculation. So it has to be assessed in the light of all relevant facts and circumstances. In this incident, the value of the salved property can certainly affect the reward. But I have to note that the value of the salved property in every given is yet to be officially assessed. But I have seen some initial reports which estimated the value of the vessel approximately around 125 million USD, and the value of the cargo approximately around 500 million USD. But there are varying figures and reports on the media. Therefore, it can take some time to establish the salvage reward in this incident. We don't know what the salvage award is going to be yet. But the bottom line is that obviously that is going to be a very large salvage award, applying the criteria of Article 13 of the Salvage Convention. Salvage Convention also allows a reward for what is called special compensation under Article 14, the prevention of pollution or environmental damage. And in this incident, we don't know yet, but technically salvors may claim this under Article 14, but in my opinion, this seems very unlikely. And the salvage reward will be mostly covered eventually by hull and machinery insurance. And theoretically speaking, if there was any scopic reward invoked, and this would be covered by the UK P&I. And most cargo insurance policies adopt the institute cargo clauses, in which delay is excluded. But however, I'd like to note that ICC covers salvage charges. And finally, salvage remuneration has to be proportionate. And I'd like to refer to the Americ case, which dealt with these huge values. In this case, the judge said, the rule seems to be that though the value of the property solved is to be considered in the estimate of remuneration, it must not be allowed to raise the quantum to an amount altogether out of proportion to the actual services rendered. It appears to me this can be a good point to be taken into account in the ever given incident, considering the huge value of the solved property. To conclude, we have a huge solved value in this incident, but we have to note that this salvage operation took only 6 days. Certainly, the salvage reward may be generous, but still it has to balance the value of the actual salvage service carried out in this incident. Over to you, Sinem.
Thank you, Mr. Sumer, for the great explanation. Yes, it was great that you put all these inputs. I apologize because we're running out of time a little bit. So I see that we have many questions, in fact, but I'm trying to take just a few of them. So the ones that I cannot take it, you can send your questions directly to info@maplow.co.uk. And I can direct your questions to one of our speakers and get back to you as soon as possible. So I would like to take one of the short questions from Prashant Lal. Jeffrey, perhaps you would like to answer this question. He's asking, what would be a realistic claim by Suez Canal Authority on the owners of the Ever Given? Is $916 million justified?
Great question, Prashant. Thank you. And for the rest of you, Prashant is actually one of my pupils. So, is it justified? Well, if they add up all the items, including loss of face or reputation, which was, I think, something in the region of 300 million, which was already discussed, then 916 million may well be, in their opinion, justified. As I mentioned earlier, in my opinion, much of this is a smokescreen to take people away from the view that the Suez Canal Authority or its employees caused quite a lot of this incident, in my opinion. And I look forward, frankly, to seeing that being proved, because I will use the word again, smokescreen. There seem, from what I've heard and from what I've read, there seem to be quite a few reasons to send a counterclaim in the direction of the Suez Canal Authority for what they did, or perhaps we should say what they did not do. Of course, to answer Prashant's question specifically, the Suez Canal Authority would obviously say that their claim is justified. I think it remains an open question as to whether courts and various jurisdictions will agree with that. I'm being slightly obtuse because, of course, there's no clear answer just yet, but to give it a broad brushstroke, the SCA obviously think it is justified, and frankly, I have my doubts. I don't know whether the others want to pitch in here as well, perhaps.
Thank you, Jeffrey. I think you answered the Prashant's questions. Well, I don't want to be out of the time. So I would like once again to repeat the attendees for their attention. If you have further questions to any of the speakers, you can send your questions to info@maplo.co.uk, and I can revert your question to the relevant speaker, and get back to you as soon as possible. So I would like to, if you allow me to come into the closing remarks, I would like to once again, on behalf of Maplo, would like to say thank you to all the speakers for their contributions and for taking time to be with us today. And of course, thanks to all the audiences for their participation. So I would say we have understood that as vessels continue to increase in size and complexity to accommodate rapidly growing demand for goods from all corners of the globe, the infrastructure which is relied upon so heavily to facilitate the movement of cargoes has become increasingly valuable to global trade, while at the same time significantly more vulnerable to disruption. Yes, the Ever Given case will continue to be discussed for a while. But in my opinion, this should be seen, before we were saying, I think this before, but this should be seen as an alert to encourage all the actors in the shipping sector for better risk management and planning for future events which may even not be so quickly resolved as in the case of Ever Given. Once again, many thanks to everyone, to all the speakers, and I would like to wish you a good evening or a good morning wherever you are. Thank you. Have a good day.
Thank you. Goodbye.
Thank you very much for everything. Bye.